Good evening, friends. I am Ashok Arora, advocate, going to discuss the concept of anticipatory bail. We are all aware that not a single day passes when someone is not accused in a case. Nowadays, domestic violence act is being mostly used in 498A. Even full family is booked. So the one had to take legal measures, that is anticipatory bail. So we will discuss in detail the concept of anticipatory bail. If we go through CRPC, you will see nowhere the anticipatory bail is defined. Even the bail is not defined. But to talk of anticipatory bail, but there is mention of bailable offences and non-bailable offences. When someone is booked in non-bailable offence, he has to take anticipatory bail to avoid his unnecessary imprisonment. High trials takes lot of time, so one has to take this precautionary measure. The term anticipatory bail, as I told, is nowhere defined in the Criminal Procedure Code 1973. However, the first mention of this said term can be seen in the 41st Law Commission Code 1969, where the Commission felt the need to include a provision for protecting an accused or any person who is apprehending or having a belief that he or she may be arrested for any offense which is non-bailable in nature. Taking into consideration the said report and grave need of the hour, the Parliament, while enacting the CRPC 1973, added a provision to for pre-arrest bail under Section 438 with heading Direction for Grant of Bail to Person Apprehending Arrest. Now coming to the evolution of anticipatory bail in criminal jurisprudence. Before proceeding with the law of anticipatory bail or pre-arrest bail, it is important for us to understand the history behind the origin and evolution of the provision of bail as we know it today. The origin of bail dates back to medieval times when the first known draft constitution came to be enacted in the year 1215 by King John of England and were referred to as Magna Carta. Very popularly, we all know. The genesis of bail can be extracted from the clause 39 of the Magna Carta, the simple translation of which I am going to read. No man shall be seized or imprisoned or stripped of his rights or possessions or exiled or deprived of his standing in any other way, nor will we proceed with force against him or send others to do so, except by the lawful judgment or by the law of land. From the perusal of this, we can say idea or clause, it can be understood that a person shall not be restricted or confined unless and until there is a final judgment in accordance with the law of the land. On the careful reading and decoding of this clause, we can greatly relate the said provision with the provision of bail as provided in CRPC. The old CRPC of 1898 did not have provision for anticipatory bail, pre-arrest bail. As mentioned above, the idea of anticipatory bail or pre-arrest bail was first recommended to the Parliament only under 41st Law Commission report, post which the provision of anticipatory bail or pre-arrest bail was incorporated in Chapter 33 of the new CRPC 1973 under Section 438, which reads as under. It is a lengthy one. You are all having CRPC, so you can go through that. I will analyze in few words what is that. It is having three sections, subsection 1, 2, 3. By amendment of 2005, in section 1, there was addition of 1A and 1B. Now, before filing case, we have to be knowledgeable which court has original jurisdiction to entertain application for bail. When a person has an apprehension or reason to believe that he may be arrested for accusation of having committed an offense which is non-bailable in nature, he may apply to High Court or Court of Session for direction to the investigating agency that in the event of arrest, he shall be released on bail. Now, as I promised, I am analyzing section 438 of CRPC. This section is divided into three subsections which have been analyzed. Firstly, I am analyzing subsection 1. According to subsection 1, any person can apply for anticipatory bail if he has a reason to believe that he may be arrested on accusation of having committed non-bailable offense. Here the legislator were clear that such an application can only be made if the offense for which anticipate application is filed is a non-bailable offense. This subsection 1 further provides that such an application can only be moved before the High Court or Session Court that is empowered to give direction to the investigating authority seeking arrest of such applicant to release the applicant on bail in case of arrest for non-bailable offences. However, the Parliament in the year 2005 brought in an amendment requiring the courts entertaining such an application to be more cautious while granting any relief under this provision. The amendment brought in the list of guidances that is, the court shall take into consideration the gravity of offense. The court shall take into consideration the antecedents of the applicant and also look into the possibility of applicant avoiding the trial by fleeing. If anticipatory bail is granted, the court shall also consider if the accusations made in the FIR made with the intention to harass the applicant, or the subsection 1 further states that in case the application for anticipatory bail application has been rejected by the concerned court, or if internal relief is not granted while the pendency of the said application, that it is open for the investigation to arrest the said applicant without warrant on the basis of accusation apprehended in such application. Here the legislature has given secret powers to the investigating authority to take into account the apprehension made out by the applicant and to consider his apprehensions as alleged crime and arrest him to investigate why he is apprehending such an arrest. Now, further subsection 1A, which was added in 2005 amendment, it states that in case internal relief has been granted by the concerned court, then a notice shall be issued to the public prosecutor and the SPDCP, which should be not less than 7 days, in order to give reasonable time to prosecutor to defend the said application before the application is finally heard. By inserting this provision, the Parliament made it very clear that if the court is not forthwith rejecting the relief for anticipatory bail and the court has prima facie found any merit in the application, then the application under this section cannot be disposed of unless and until the public prosecutor is heard. The second subsection 1B, which was added in 2005 amendment, further says that if the public prosecutor makes an application before the court where the anticipate bail application is pending, then the presence of the applicant is required during the final hearing or at the time of passing final order. And if the concerned court deems it necessary to allow the same, then the presence of the applicant is obligatory and compulsory. Thus, although this section gives powers to the public prosecutor to ask for the presence of the accused, but it is the discretion of the court whether to call him or not. Coming to subsection 2, this section lays down certain conditions which need to be put on the applicant while granting him internal protection. Subsection 3 states that if the application under this provision is allowed and if such a person is subsequently arrested without warrant, then he should be released on bail immediately in case the magistrate takes cognizance and issues a warrant against such person, then such a warrant shall be bailable. So, the concept of anticipatory bail. Sometimes one says if anticipatory bail is granted, then person will be arrested or no. Yes, this order will come into play when the person is arrested. But the relief is at the same time it fulfills the criteria, the order's requirement, then he will be released immediately. Otherwise, in other cases, when he is arrested, there is no anticipatory bail. Here I to go through lengthy process which takes time. Here the immediate relief is immediate, but arrest is must. If there is no arrest, then no need of implementation of anticipatory orders. So, what are the prerequisites of the for grant of anticipatory bail? These are the offence against which bail is sought should be a non-bailable offence. Secondly, there should be a great apprehension, not a simple impression, great apprehension that the accused will be arrested by the police authority for such a non-bailable offence. Sometimes offences are below having punishment below 7 years. In that case, the investigating officer may arrest or may not arrest. So he had to give notice under 41A. He had to complete that formality of provision. Otherwise, he cannot arrest a person. Now coming to recent landmark judgments on the law of anticipatory. I will discuss the issues connected with bail application, what type of issues are raised, and how this anticipatory bail is giving them relief. Firstly, the question might be in your mind whether there is time limit for which the anticipatory bail is granted, or it is up to the end of trial. There is one case law, Shishila Agarwal versus State of Delhi. The Honorable Court was pleased to frame two questions while deciding the landmark judgment. That was whether the protection granted to a person under Section 438 of CRPC should be limited to fixed period so as to enable the person to surrender before the trial court and seek a regular bail. Second question decided in this landmark judgment was whether the anticipatory bail should end at the time and stage when the accused is summoned in the court. The constitutional bench of the apex court was pleased to answer the first question by holding that there can be no time limit set for anticipatory bail by the court granting the same. The five-year bench was pleased to unanimously hold that protection granted to person under Section 438 CRPC should not invariably limited to a fixed period. It should be in favor of the accused without any restriction on time. And answering the second question, the Honorable Court held that the life or duration of an anticipatory bail order does not end normally at the time and stage when the accused is summoned by the court or when charges are framed, but can continue till the end of trial. Again, if there are if there are any special or peculiar features necessitating the court to limit the tenure of anticipatory bail, it is open for it to do so. So discretionary power the court have to restrict the time limit. Otherwise, in normal cases, it is up to the end of trial. The Supreme Court was cautious while answering the second question by granting discretionary power to the court to limit the tenure of anticipatory bail in case of special or peculiar effects of the case. Now, second question, which has been put by me, Mr. Dunova from Roper, that is, not granting anticipatory bail may cause violation of fundamental rights of an individual under Article 21 of the Constitution of India. Mr. Dunova, the court has to see, we can say our law has to see three things. It has to protect the society. Secondly, it has to see that the courts are, which are already heavily populated, are not overburdened, as the money spent on the accused while in jail is from public exchequer, taxpayers' money. So, and third, one has to see the constitutional provision, that is Article 20, which safeguards the life and privacy of the accused. So, balance act has to be made by the court. This, your particular answer was decided in the case by the Honorable Supreme Court in the case of Badresh Bipanbai Seth, BB Seth versus State of Gujarat, in which it was the court was pleased to hold that the provision of anticipatory bail enshrined in Section 438 of the Code is due to Article 21 of the Constitution, which relates to personal liberty. Such a provision calls for liberal interpretation of Section 438 of the Code in the light of Article 21 of the Constitution. The court explained that an anticipatory bail is a pre-arrest legal process which directs that if the person in whose favor it is issued is thereafter arrested or accused in respect of which the direction is issued, he should be released on bail. Now, the apex court, while observing the above two provisions and related them together, the court was pleased to observe that Section 438 and Article 21 goes hand in hand, and that by enacting the provision for grant of anticipatory bail, the legislature has upheld the fundamental right of citizens. Sometimes the compliance of 41A of the CRPC is not. Is it mandatory? In case of offences punishable with maximum 7 years of. His answer was this question was explained by the Honorable Supreme Court in the case of Arnesh Kumar versus State of Bihar. While deciding an application for anticipatory bail for offences under Section 498A, which are nowadays everyone is booked, even the whole family is booked. That's why this anticipatory bail is given liberal interpretation. It felt that there should be a mandatory notice under Section 41A to be sent to the accused if he is booked for offences with punishment of 7 years, only up to 7 years. Now, coming to the right of informant or the person who has put in motion the legal system by registering an FIR, he should be listened at the stage of anticipatory bail. This question is answered here. The Honorable High Court of Bombay, in the case of Vinay Potdar versus State of Maharashtra, held that if the victim of the offence appeared in the court seeking permission to be heard, then opportunity of being heard is to be given to him or her. However, the Supreme Court, in the case of Sandeep Kumar versus State of Maharashtra, took a slightly contrary view to what was discussed. The court held that the upshot of this analysis is that no vested right is granted to a complainant or informant or aggrieved party to directly conduct a prosecution. So far as the magistrate is concerned, comparative latitude is given to him, but he must always bear in mind that while the prosecution must remain being robust and comprehensive and effective, it should not abandon the need to be free, fair, and diligent. So far as the Sessions Court is concerned, it is the public prosecutor who must at all times remain in control of the prosecution, and counsel of the private party can only assist the public prosecutor in discharging its responsibility. The complainant, informant, aggrieved party may, however, be heard at the crucial and critical juncture of the trial so that his interests in the prosecution are not affected. Now, coming to the most important question, is it mandatory by the police to arrest a person only because his anticipatory bail is rejected? Supposing he is in court and no relief under anticipatory bail is given to him, can he arrest? Is it mandatory? This question is answered by the Honorable Supreme Court in case of MC Abraham and others versus State of Maharashtra and others, and has held that it is not mandatory for the police to arrest a person merely because he or she her anticipatory bail has been rejected. The Supreme Court in Gurvaksh Singh Sibia versus State of Punjab held that the power under Section 438 was extraordinary power and a petition under this section should be dealt with by the court according to the factual circumstances of the case. It further held that the Sessions Court or the Honorable High Court have wide discretion while exercising the power under the section, and legislature intent for granting such wide discretion was firstly that it would be difficult to enumerate the conditions under which anticipatory bail should be granted or not granted. Secondly, because the intention was to allow the higher courts in the hierarchy that some pre-hand in the grant of relief in the nature of anticipatory bail is given to them. We all know that this anticipatory bail concept was due to post-emergency period when people started filing FIR against the officer that they had done such a wrong during emergency period. All officers were not wrong, so to avoid that situation, so that money not unnecessarily aroused who were doing his official duty. This provision was recommended by the 41st report of the Law Commission, which was felt necessary. So this provision was coming to the most hot issue of Varun Gandhi, who is the grandson of our late Prime Minister Indira Gandhi. He was recommended to be booked by the Election Commission of India for his anti-particular caste speeches. And if this provision has not been there, his political career has been destroyed. He has been behind bars. This anticipatory bail, that is Section 38, came into his protection. We are now quite aware that our respected two councillors, even the senior ward council, Mr. Chahal, and other one, has been recently booked under serious non-bailable charges. I hope the goodwill will prevail and the matter will be sorted out amicably. If worse happens, charges are not dropped, then they have to take the leave of this anticipatory bail. So this section is a balancing section which covers both the parties, accused as well as complainant. For complainant, the accused is given anticipatory bail with so many further conditions, and for accused, the courts are following the dictum of Article 20. So that is all about this anticipatory bail concept. Thank you for listening. बंद करना सी